Being you didn't get complete your, your opening remarks, could you table those with the committee at the end of today so we could have access to those, please? Thank you so much. So, Dr. West, you had indicated publicly that a national emergency is a public order emergency, and it can't just arise from incompetence in various municipalities or provinces. It has to arise from a threat to the security of Canada, which typically means terrorism or violent extremism, and to meet the threshold to invoke the act. Now, have you seen anything, any documents, anything that you've looked at since the invocation that this threshold was met?
Well, I don't think it's fair to ask me that because I haven't seen all of the intelligence that was relied upon by CSIS or the cabinet, especially cabinet, to make that decision. My point was then, and I would make the same point now, that the key is that the threat to the security of Canada has to be what drives the emergency, rather than it being the byproduct of the emergency. And that was really the key of what I was trying to say, is that it can't be, there should be a causal connection there. That's how I interpret the statute, rather than it being something that happens as a result of another reason for the emergency.
Fair enough. So, one of the things that that I find very concerning, I think, and many Canadians do, is the precedent that will be set once Justice Trudeau releases his final report. He will essentially either agree with or disagree with the government's expansion of the CSIS definition and the thresholds, which served as a foundation for the rationale for invoking the Emergencies Act. Dr. West, can you speak to why it's so important that future governments be constrained by law and like the CSIS Act when it comes to using the Emergencies Act?
Yes. Well, I think the rule of law, again, requires that, especially where the legislature speaks and does constrain the power of the executive, that especially in times of crisis, that the executive adhere to those constraints imposed by the legislature. I think that the Emergencies Act has incredible amounts of discretion for the executive, and that would be how anyone would interpret it, whether or not it was reasonable they had reasonable grounds to believe a threat to the security of Canada existed, and then whether it was necessary. There's incredible amounts of discretion there, but when Parliament has chosen to be very narrow, in this case, in its use and definition of threats to the security of Canada, it's important that that be respected, because it was a deliberate choice, and the rule of law is the backbone of what makes us, a liberal democracy that thrives on the rule of law.
Okay, fair enough. Thank you for that. One of the things that I found interesting was at one point you actually tweeted that there were, in your opinion, there were holes in the Prime Minister's legal analysis. Can you expand on what you meant by that and what that means in your opinion?
So, my understanding of what the Prime Minister said when he testified before the PIOC was that he took into account different considerations than CSIS when making the determination as to whether or not the definition of 2C was met. And he also viewed 2C to be more broad. And that, I don't think he said that. I think he said something to the effect, I think the CCLA had him acknowledge that the thresholds were the same. But then subsequently, when asked what the factors were that led him to believe that Section 2C was met, he listed a variety of threats and of violence, of weapons, etc., that he relied on to make that decision. But I suspect that CSIS would have also relied on all of those factors when making its assessment. It didn't seem to be anything that would not have been subject to CSIS's consideration.
Okay, so if I'm understanding you correctly, the broader interpretation that we are left with that we haven't seen could include the same sort of things that CSIS was reasonably looking at. Is that what your assessment would be?
Yeah, it was. If it really was it was the fact that he suggested that he viewed the standards to be the same between the CSIS Act and the Emergencies Act, but that he relied on different factors but then the factors listed would have been factors that would have been considered by CSIS.
And when CSIS said there was no threshold under under Section 2 to meet the threshold to invoke the Emergencies Act.
Yes, that's my understanding.
Thank you. Thank you very much.
To you, Dr. West, the Prime Minister promised Canadians when he formed government that he would run an open and transparent government. He agreed to cooperate fully with Justice Trudeau when asked to testify. Yet he and his cabinet have hidden behind the principle of solicitor-client privilege in not releasing the legal advice he received. A just trust us argument is unacceptable to Canadians. Without the benefit of that opinion, you opined in a legal article, and this was co-authored by yourself, Michael Nesbitt, and Jake Norris in the the Criminal Law Quarterly, that for the government to have properly justified the declaration of a public order emergency, the government needed to base its invocation on 3 novel, unconventional, and previously unanticipated ways of interpreting this legal threshold. Can you opine on that? And the secondary question to that is, this article was written before all of the evidence was heard. Does your opinion still stand? If not, how does it differ?
So it changed slightly because we wrote that on the basis that Section 2C was being interpreted as we would interpret it in the CSIS Act. So that's what we were assuming, that when Cabinet read 2C, they read it the same way that we would have. And so not having any evidence at the time the article was written that there was such serious violence or threats of violence that would amount to 2C, we said, well, there must be some novel way of interpreting what serious violence means. And based on the Section 58 justification, we looked at what was there, and it was serious economic harm in particular. Now we've heard that it wasn't the serious economic harm. It wasn't, intelligence or evidence that wasn't available to the public. It was a different definition of 2C that was relied upon, and that was something that we had not anticipated when we wrote that article.
Okay. You appeared on CBC Power and Politics on a number of occasions during the Rouleau Commission, and the question that was put to you and another professor was what we learned from the Prime Minister's testimony. I also looked at your Twitter feed, and in a tweet in and around that same time frame, this is probably during the day or perhaps the day after the Prime Minister testified, in a tweet you said that Trudeau, Prime Minister, is making a compelling argument if you're not a lawyer. Please expand on that.
It's a lot to unpack. Basically, yes, thank you, is that what I heard and what I've heard all the way through as someone who's trying to take the facts and the understanding and apply it to the law is a lot of facts being applied to different elements of the definitions, but they're not ever necessarily in the right order. They're not, you don't meet the first hurdle before you get to the next one, before you get to the next one. They're all kind of, they're just applied as if there's not a structure to the act. So you get facts that talk about one element of the definition and then facts that talk about another, but they don't really lay it out in terms of you have to meet this threshold and this one and this one. And so I think if someone's just reading the act and isn't, someone who's a statutory interpretation nerd, you look at it and you're like, oh, well, all of the things here match up with all of the things that are in the act, so that makes sense. But that's not the way the statute's laid out. There's a series of thresholds that need to be met, and they're each word matters, and that's why I found compelling, but not if you're looking at it with through the eye of someone who's keen on statutory interpretation.
For those who may be keeping track, I am allowing the witnesses to finish their thoughts and their answers, but your intervention has been completed. We will now pass the floor